Hey everybody, it's your trusted realtor, Andrew Martinez, and today I wanted to talk to you about the Working with Real Estate Agent disclosure form. Looks like this, and it's accompanied by a brochure with questions and answers. You probably received it from me in an email. Now, we're required to go over this with every buyer or seller before first substantial contact. We also must give you a copy of the disclosure form after you sign it. Before first substantial contact means before you start to tell me any confidential information, such as your budget or your motivation for buying or selling. Now keep in mind that this form and brochure are for educational purposes and your protection only. It is not a contract. When buying or selling real estate, you may find it helpful to have a real estate agent assist you. Real estate agents can provide many useful services and work with you in different ways. In some real estate transactions, the agents work only for the seller. In other real estate transactions, the seller and the buyer may each have their own agents. Sometimes the same agent or firm works for both the buyer and the seller in the same transaction. When you're working with a real estate agent, you need to be aware if that agent is representing you. If an agent is representing you, this means you have what's called an agency agreement in place. An agency agreement is a contract between you and a real estate firm that authorizes the firm and its agents to represent you. If you were a buyer, this is called a buyer's agency agreement. If you were a seller, this is called a listing agreement. There is also a form of agency called dual agency that I'll explain shortly. With these three forms of agency, there are 6 duties that a real estate agent owes you as their client. Number 1 is they must always promote your best interest, even if it's not in the best interest of themselves. Number 2, they must always be loyal to you, their client. Number 3, they must follow your lawful instructions. Number 4 is disclosure, which means they must provide you with all material facts that could influence your decisions. Number 5, they must use reasonable skill, care, and diligence. And number 6, they must account for all monies they handle for you. Now let's talk about dual agency. Dual agency is when an agent or firm represents both parties in a transaction. An example of this would be if you listed your property with me or my firm, and another agent in my firm brought a buyer who is interested in purchasing your property. In this case, we would need to get both parties' permission to allow for dual agency because we would be representing both parties in the transaction. And it's very important to keep in mind that dual agency creates a potential conflict of interest for the firm that represents you, since its loyalty is divided between you and the buyer. Dual agents must treat buyers and sellers fairly and equally and cannot help one party gain an advantage over another party. If you as a client are not comfortable with entering into dual agency, that's fine. You don't have to agree to it. There's also another option to minimize the conflict of interests, and this would be to request a form of dual agency called designated dual agency. And this is when one agent in the firm represents only the seller and another agent within the same firm represents only the buyer. We're still in dual agency, however, both parties are being represented by their own agents and neither party know any confidential information about the other. I hope this video helped you better understand the different forms of agency in North Carolina, and as always, I look forward to helping you on your real estate journey. Thank you.